Good afternoon, dear ladies and gentlemen, dear colleagues. I haven't understood anything what was said in Latvian before, even if our languages are said to be similar and belonging to the same family, but unfortunately I heard only Lithuanian and then my name. I'm not that good in Latvian. So first of all, I would like to thank the organizers for having this conference on this day when GDPR becomes applicable, and the day which is very significant and for which we have been waiting, or maybe some of us were not waiting for it, but in any case it came. So yesterday when I was on my way to Riga, I accidentally heard a conversation of my neighbors on the phone, and it appeared that a lady owns a small business and she was talking to her friend about GDPR and how to comply with it. And you know, it brought a smile on my face, because earlier it never happened in my life that I would hear anyone talking about data protection in such an everyday life situations like this. And yes, we had 2 years to get ready for this day, and I have here this rhetorical question. Is it too much to do and not enough time? And as in Lithuanian, we have a saying that every student needs one more night before the exam to get properly ready for it. So I think you maybe have the same saying in your language, and I think it perfectly fits to the situation we are in. Even though we were putting a lot of our efforts, a lot of our work, maybe not everything went so well as planned. And I think across Lithuania we would get a very scattered picture of both companies and public sector institutions, if they are ready by the date or no. And I really liked one saying from our German colleague who was saying that when we were thinking that we are getting ready for the application of GDPR, it appeared that we are getting ready for Directive 95, because some of the companies didn't know about the existence of this directive and national laws that implemented this directive. And they were surprised to get information about certain criteria for processing, about basic principles which are understandable. And yes, so we have a situation as we have, and we have to deal with it. And I believe that those companies who were taking data protection issues seriously and were working on it on a constant basis, we are more ready today than those who were not taking care of how to protect personal data that they process, or not putting enough of effort to be ready by the date. And here we have public and private sector data controllers, and both sectors raise their concerns and criticism about the application of GDPR. We have heard that GDPR is not possible to be implemented, that there are a lot of not clear requirements in GDPR. There are no numbers in GDPR. What does it mean? High risk or large scale? So large scale, how many subject data do I have to process in order that my processing would be considered as processing in large scale, and so on. So when we have drafted our national law for the application of GDPR and we made it public, there were such comments that we should regulate on something more, we should make certain requirements of GDPR more clear, and so on, but we simply can't do certain things, because the GDPR doesn't give a mandate for the member states to regulate certain issues. And here we have that negative moods, but on the other hand we have very positive effects of the GDPR. And even if a lot of people were not happy when they receive all these emails or SMS messages in the last weeks, where they were asked to give their consent, or we were informed of new data protection policies. But this also means that we got to know more than they knew a day before about data protection, and that they maybe have new rights, and those who are interested, they can go in deeper and seek for more information. And here I see that the role of National Data Protection Authority has increased. And these last weeks have shown that a lot of companies were waiting for the last moment to comply with the requirements of the GDPR. And that the hotline of DPA is really hotline, because not everyone can call to them and ask for advice nowadays, because the line is always busy. But what can we do? The DPA has as many people as they do, and the advices maybe will come a bit later, the ones that are needed. And I think that we actually live in a very live and work in a very interesting time, when the new practices regarding GDPR will be established. Then there are new explanations on how certain things, principles work, on how this one-stop shop gonna work, on how European Data Protection Board will work, and what opinions we're gonna give, and how they will influence our future work. And I come from the Ministry of Justice, and we are not only a big data controller, but we are also the public institution that is responsible for shaping state policy in the field of data protection. Therefore, I would like to talk more about our national laws, what we have drafted while getting ready for the application of the GDPR. And in this case, I'm talking only about laws on GDPR, because we have this law enforcement directive, which had to be implemented earlier this May. And we have chosen to have two separate laws on GDPR and directive. And now I will focus on this law for GDPR. So the draft law was prepared, first of all, by the working group that was created by the State Data Protection Authority. And I used to work there at that moment when we started our work, and the working party was established straight after the GDPR was adopted. That was in May 2016, so like the next month after the adoption of the GDPR. And the draft law was prepared, and then it was given to the Ministry of Justice, where I started to work as well, further with this law, just at ministerial level. And we made our draft law available for public 1 year ago. That was in June 2017. As we were expecting, we have received a lot of comments and suggestions on how to improve our draft law. And therefore, we have decided to organize a special event with interested parties who had given comments on law, and we have chosen to talk about 4 issues that we were interested in. That was about our regulation on national identification number. Then it was about age of child for consent. Then it was certain issues of data processing in financial sector. And the last question was about the employment sector. And according to those comments we have heard, we have changed our law accordingly, and it was given to passed to the government, and now unfortunately we don't have a law at today. It's still undergoing the procedures at the parliament. We, as a government, have asked for the urgency procedure, and we hope that the Parliament will adopt our law by the end of June, or in any case the summer, before the summer holiday begins. Together with this main law on legal protection of personal data, we have drafted 9 other laws that were necessary for application of GDPR, as we thought, and that were directly connected with general law on legal protection. So these laws included law of government, where we needed to ensure necessary guarantees of independence for the State Data Protection Inspectorate. We have also made changes to our administrative liability code and so on. And that does not mean that only law on legal protection and 9 other laws have to be changed. That means that there are a lot of other sectoral laws which may not fully comply with the GDPR at this moment. So we have this ongoing work with sectoral laws, and it's responsibility of every ministry to overlook those laws and to work further with them and draft laws and give proposals to the government. Our government has decided to establish a commission from representatives of several ministries and other related public authorities that will help the ministries to do this homework and coordinate how the things are done at each ministry. And the government said that these draft laws have to be ready by the 1st of September later this year. So we have not an easy summer waiting for us, because there has to be quite a lot of job done by the date. And now I would like to talk about certain provisions of our draft law that we have decided to regulate, where we allow to do so by the GDPR. So first of all, we have certain provisions regarding personal identification number. As I said, we had public consultations regarding this issue, but we decided to keep the rules that were actually enforced before today. So one of the provisions say that personal identification number cannot be made public. That means that nobody can publish it, for instance, on the internet. And the other provision says that personal identification number cannot be used for direct marketing purposes, because earlier, several years ago, we had even a case at the court where one of the companies wanted to use this number for such purposes. Then we have provisions regarding processing and freedom of expression and information. These provisions are made according to the Chapter 9 of the GDPR. So here we say that certain articles of the GDPR are not applicable when data are processed for these journalistic purposes. Then we have regulated on processing in the context of employment. And these provisions say, for instance, that the employer cannot gather information about his worker or candidate to work at his company regarding criminal convictions, unless it is necessary to check if a person is in compliance with the requirements set in the laws. Because we have this practice, then companies asked their workers to bring those documents about criminal convictions, and it was believed that it is done on the consent of the worker, but we don't think so. So here we have quite a strict rule that consent cannot be a basis for processing of criminal convictions data. Then we have several other provisions, for instance, regarding the surveillance of workers' behavior, its monitoring, video surveillance, and so on. This means that the company has to inform the worker in written form or in other form that shows that worker received all the information according to the GDPR, so that it could not be done secretly without the worker's knowledge. Another provision we have regards the child's age to give consent in relation to information society service. First of all, we fought not to regulate on this issue at all. We wanted to follow the general rule that is established in the GDPR, that is age of 16. We have consulted children rights ombudsman, and he was of the same opinion that the child's age of 16 is a good choice because it's in the interest of child, and we should have this safeguard and keep this age limit. But when after public consultations with private sector, we had lowered this age to the age of 14. We have not chosen 13 years, which is allowed by the GDPR. We remained with 14 years because this age limit is foreseen in our civil code when a child can get certain civil rights. So we are just following the logic. If a child can buy some goods, why couldn't he receive some direct marketing messages regarding the same goods? And then one of the other specialties we have is administrative fines. We have chosen to impose fines on public sector, but the fines are not the same as those foreseen in the GDPR, those 10 or 20 million. We have chosen a lower level, and it would be 30 or 60,000 accordingly. Unless the institution is involved in commercial activities, then in such a case, this institution could be imposed with a fine foreseen by the GDPR, that is up to 10 or 20 million. Regarding supervisory authorities, we have actually two supervisory authorities till today, and we are keeping our system. Main supervisory authority is the State Data Protection Inspectorate, and then we have another player in the field, that is the Inspector of Journalist Ethics, and he supervises the data processing when these data are processed for journalistic purposes. We have this system now, and we are keeping it like this later on. As I have already mentioned, one of the necessary things to regulate on was independence of DPAs, ensuring the necessary guarantees so that these supervisory authorities would have all the independence that is required under the GDPR and Law Enforcement Directive for the state. In the case of State Data Protection Inspectorate, as it is also a supervisory authority in the scope of the directive and national law implementing the directive. And as I have mentioned before, we have foreseen some independence guarantees also at the law of the government, because State Data Protection Inspectorate is a governmental institution. It's under government and not under parliament, as in some other member states. And one other thing that we have had to regulate on is which authority will be responsible for accreditation of certification bodies, because the GDPR foresees that this can be done by supervisory authority or by national accreditation body, or by both of them. So in this case, we have chosen that accreditation will be done by our State Data Protection Authority, that is supervisory authority. And that would be a short short information about our draft law. As I said, it's only a draft law yet. We don't know what's going to happen to it after we finish all the parliamentary procedures, because as any other member state, I think we have members of parliament with different ideas what could be added here, or what do we need to regulate more precisely, and so on. So we'll see how this work will go on. So I would like to thank you for your attention.
Thank you, Indre. One thing that probably you didn't understand in one of the presentations was from our DPA, and they mentioned that all the ministries are ordered to review all the laws in their competence to see whether there have to be some amendments. Maybe you have some comments about this process in Lithuania, because you told about the data protection law, but how about everything else? How is this done?
Yeah. I mentioned a bit about it.
Yeah, but how it's going? Is there some progress, or it's just starting?
I could say that it's different from one ministry to another one, because we were giving comments on draft laws that were sent, for instance, to the Ministry of Justice for, I think, almost 2 years. After the Gdpr, we started writing that pay attention to the Gdpr. Maybe you already regulate in accordance to the requirements of Article 6, for instance, so that you wouldn't need to change these laws later on. But now the government this spring has decided to give this term of revision to the ministries. So I think the process will be faster now, because we have this 1st of September in 3 months and a bit. And it's not a long term when you think of all the laws that have to be reviewed and changed in the case if they are not if they not comply the requirements of the GDPR. So a lot of work is waiting for us, actually.
For everyone, probably. So maybe some questions or comments from.
Yeah. Hi, DPO. From financial institution. I have a question about this registration of controllers. Did you have before, and will you have afterwards, starting from today, is this registration of controllers?
Yes, we have the registration of controllers because it was foreseen in the directive and foreseen in our national law, and we have the public register of data controllers who were registered at the State Data Protection Inspectorate. No obligation to register as a controller as of today.
Okay.
So the information in the register also becomes not actual, and it may be even it can even mistake someone because we can't trust on the information that is registered, because the situation at the controllers might change, and what they had made known to the DPA like half a year ago might not be the same tomorrow or in a week.
Okay, so this registration is cancelled. About DPOs, about registration of DPOs and qualifications, anything? Yeah.
We are not regulating on this on our national law, because we think that there are requirements, like basic requirements foreseen in the GDPR, and no additional requirements are foreseen for our DPOs.
And registration of DPOs, no? In inspectorate?
It shall be done by the inspectorate.
Okay.
I don't need to have any information on how many are already known to them.
Thanks, yeah.
Thank you. Any other questions, comments? So then I think we can all go to the coffee break, and for those who are interested, be back at 4.